Donald Trump files another appeal to the Court of Appeals in the D.C. Circuit, this time asking for the full court to hear the case. It's involving the gag order. Chutkan has issued a gag order saying Trump is not allowed to speak, and we have a problem with that because we're in the middle of an election. We want to hear from him. And so he's already been rejected by the Court of Appeals. He's asked for the gag to go away so he can say whatever he wants about Jack Smith and all of the other reasonably foreseeable witnesses that are in the prosecution being brought by Jack Smith against him. But Trump appealed to a 3-judge panel at the D.C. Circuit, and now he's asking the full court, all of them, to hear it. And he's got to get permission for them to do that. And so the judges are going to vote on this. They're going to basically say, well, did the 3 judges who already heard the case, did they cover it? If they covered it, then we don't need to hear it. The rest of us don't need to opine on it. But if they disagree with what the 3 judges did, then they will ultimately hear the appeal. And of course, no matter really what happens, I think Trump has the option to go to the Supreme Court, but he'd like to just get the Court of Appeals to rule in his favor and make Jack Smith do the appeal rather than Trump lose and then go to the Supreme Court. So they're battling ahead. We're going to learn what this word means, en banc, and this is describing the process for what happens. Here in federal courts, sometimes appeals court will grant a rehearing, because we've already got a hearing on this one, to reconsider a decision from the court panel. That was only the 3 judges. We've already covered that one here. Cases in the United States are generally heard by 3-judge panels, randomly chosen, but if a party loses, then they may appeal for a rehearing en banc. Now, the majority of the active circuit judges, so in this case, the DC judges, they must agree to hear or rehear the case en banc. The federal rules say that en banc proceedings are disfavored, but they may be ordered to maintain uniformity of decisions within the circuit or if the issue is exceptionally important. And we're talking about an election 2024, and we're also talking about free speech and due process and the criminal proceedings. So we've got 2 major issues that are coming to a head. So now that we know what that means, let's take a look at the actual opinion. Trump appeals in the United States Court of Appeals for the District of Columbia. You see that they want oral arguments worst heard on November 20th, and now they're asking for the full panel to reconsider the case. They say this is a petition for a rehearing en banc to request a stay of Chutkan's gag order. Signed by the usual suspects on Trump's team. We see our friends, we see the table of authorities and the glossary, and we get right down into the meat and potatoes. They tell us, this petition, Court of Appeals, presents a question of exceptional importance. Whether a district court, in this case Judge Chutkan, whether Chutkan may gag the core political speech of the leading candidate for president of the United States, disregarding the First Amendment rights of us, over 100 million American voters, just based on speculation about undefined possible future harms to the judicial process. Just made up stuff. Now, the Supreme Court has never allowed the government, never, to prohibit candidates from communicating information to voters during an election. Never happened in this country. Neither has the prosecution of a president. But guess what? The circuit court, the panel, the 3 judges, they did just that. Trump is not allowed to speak. And zooming back out for just a minute, remember that the big part of the problem with the gag order was it is very difficult to ascertain what is prohibited. And a part of the gag is that any reasonably foreseeable, that's the word, witness that Jack Smith might intend to call is off limits. And we ask ourselves, well, that's a pretty big universe of potential witnesses. There's a lot of people there that were there on January 6th. I mean, the DOJ said this was the biggest, most massive investigation of all time, blah, 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 right? They just talk it up every time they get. So in this case, they're not even allowed to speak now. And carrying on, they say this opinion from Chutkan at the lower level court, it holds that Trump must be silenced to protect the trial participants, all of those unknowns, from possible threats or harassment from unrelated third parties, right? And it's the heckler's veto. So other people are talking and their words are causing other people, not the person doing the speaking, to do something, and that third person does something that impacts the witness, and then Trump is responsible for that. So in doing so, the opinion conflicts with the decisions of the Supreme Court and other circuits, and it warrants an en banc consideration, meaning all of the Court of Appeals needs to hear it. Why is this important? Well, exceptional importance. This is an election. And they tell us that first, the reason why the full court needs to hear this is because the panel opinion, the 3-person panel, it actually contradicts the Supreme Court precedent. It deepens a pre-existing circuit split and it gags a criminal defendant. Now, when we're confronted with this 2-way split, the panel adopts a third standard. So just to explain this, we got 2 different opinions, right? We have like track A that we could pursue if we have gag problem like we have here. We have track B. One circuit has said track A is right. One circuit has said track B is right. But now the Court of Appeals in DC, they have track C. And so they're just confusing the matters. Plus, they cite no authority for that third track. So in so holding, the panel reasons that the Supreme Court repudiated a long-established clear and present danger test back in 1978 when they decided this. So they say that's a problem, right? That's why we need all of you to hear this case, Court of Appeals, because the 3 knuckleheads that wrote the opinion right now, they came up up with a third option. They're not even in category A or category B. So second, the panel opinion, it also conflicts with the Fifth and the Sixth Circuits on the critical importance of what does campaign speech mean? Campaign. Though they differed on the governing standard, both Ford and Brown, two cases, reached the same result. In both cases, the candidate defendant was given nearly, quote, absolute freedom to discuss his case during the pendency of the campaign. We looked at a case called Brown. Maximum freedom. Now, the panel opinion out of the Circuit Court, the Court of Appeals, by contrast, they authorize extensive restrictions on the core political speech of the leading candidate for president based on effectively non-existent evidentiary justifications. And third, the reason why the rest of the court needs to hear this is the panel opinion conflicts with the Supreme Court as well and other circuits by justifying speech restrictions based on the heckler's veto theory. So Trump says something and a reaction of an audience member, which has not even happened yet, okay, but it's only anticipated, that's a problem. Trump can't say something because if he does, somebody might hear it and do something bad. You see how much that requires you to speculate into the future? What does he say? We don't know. He hasn't said it yet. Well, what is the person going to hear when he says it? We don't know. They haven't heard it yet. Well, when they hear it, what is he going to do? We don't know. They haven't done it yet because he hasn't spoken. But he's gagged from that, right? And you talk about, man, what a limitation on your free speech. It almost limits your free thinking. Like you can't even think about that stuff because you know you can't say it. So the panel opinion justifies this reasoning on the basis that the audience is not hostile to President Trump. But that justification contradicts the incitement doctrine. And fourth, the reason why the main court needs to hear it is the panel opinion conflicts with the Supreme Court precedent that requires a solidity of evidence to justify any limitations on speech. So if you're going to gag somebody, it cannot be just about Trump just shooting from the hip and you think that he says something and that something might cause something bad and therefore that's evidence. That's not evidence. And by the way, just to put a pin in this, remember that anytime somebody does something that's threatening or harassing, that's already a crime. Okay, so what they're doing is gagging Trump when if he said something and somebody did something bad based on what he said, first of all, if Trump committed a crime, it would already be criminal because he would be inciting, okay, and he would be guilty under Brandenburg if he got charged with a crime for whatever they charged him with. But that's not happening here. And here, what we're seeing is he's just making regular campaign statements, and they say that somebody might possibly do something, and that alone is bad. Now, Trump might be prosecuted if he says something criminal, but if somebody else does something criminal based on what Trump said, so Trump says something and then that person becomes threatening or harassing, that person can be charged with a crime, and it happens all the time in this country, which is why I freak out every time Joe Biden says, text me on X. He posts his phone numbers, text me. I'm like, do not send him anything, okay? Because they'll charge you with that. They'll charge you, the Secret Service will show up at your door if you say something that's even borderline, right? So they have that capability, right? They already prosecute these things. They're already set up to stop this type of stuff throughout the entire federal government. But when Trump does it, Trump says something, they're going to turn around and say, gag, got to gag him. Because it's not about protecting anybody. It's about stopping Trump from speaking to his base, because every time he speaks to his base, he goes up in the polls. They keep winning. He keeps going up. So here they say the prosecution presented no evidence of any threats or harassment to any prosecutor or to potential witnesses or to court staff, the only people that were ultimately protected by the gag order. During the case months-long pendency, nothing happened. Likewise, Jack Smith presented no evidence that any prosecutor, whether potential witness or other, that they ever felt intimidated by Trump's speech. Nothing. Like, didn't present evidence, despite the prosecution's unique access to those persons. In other words, like, they could have brought Jack Smith or Molly or Thomas Wyndham. They could have brought some court clerk staff, okay? In the New York case, we got Areola's Engeron and his Greenfield, okay? For example, written an affidavit. I'm feeling threatened. I'm feeling harassed. Given it to Jack Smith. If she was Jack Smith's case, he could have gotten, Chutkin's GF or whatever. Who was there? Who's feeling threatened? They didn't provide any evidence. They just said that there were some bad statements. Now, finally, Trump's defense says the opinion warrants a full panel hearing because it overlooks and it misapprehends points of fact by mischaracterizing the context of Trump's public statements. It overlooks and it misapprehends numerous points of law, as they'll detail for us. Now, they say on December 13th, the district court stayed the proceedings pending the outcome of Trump's appeal. But the district court, however, said that even though everything else has been stayed, Chutkin is going to enforce the gag. All right. So Trump really wants out of that as well, saying, hey, everything else has been stayed, by the way, stay this one also. Saying, here's the argument. Now, the panel opinion, the three judges, it conflicts with the other rulings. The Supreme Court, Fifth Circuit, Sixth Circuit, there's a standard for gagging a criminal defendant's speech. For example, the Sixth Circuit held that gagging a criminal defendant's speech, in this case, you could read this word as Trump, it requires a showing of a clear and present danger. So if Trump is going to be gagged on January 6th, clear and present danger is necessary. In Brown, similarly, considering a gag order, the Fifth Circuit came to the opposite conclusion. Okay, so we have a split here. It said, no, clear and present danger is not what we're looking for. It's instead the substantial likelihood of material prejudice. Okay, so much, much lower. If Trump says something, he can be gagged, according to the Sixth Circuit, which I think is the better standard, a clear and present danger. Okay, it gives you more free speech. If it is a clear and present danger, then you can be gagged on it. But the Fifth Circuit said, no, we want to lower that. If there is what we think is a, quote, substantial likelihood of material prejudice, then that's good enough for us. Now, what is that? Confronted with this circuit split, the panel then came up with a third standard. They said, they came up with their own rules. They said, we want to make it a significant and imminent threat to the fair and orderly adjudication of the ongoing criminal proceeding. Like, oh, gosh. Can you guys just come up with an equal standard here? Like, you see how much wiggle room there is in all of this? A significant and imminent threat and a fair and orderly adjudication of the ongoing criminal proceeding. Well, like, my opinion of orderly is very different than Chutkan's. Imminent threat and significant, okay, is a different word. We're gonna have different word choices there. The panel, out of the Court of Appeals, out of the DC Circuit, they cited no authority for this test. Okay, they just pulled it out of their derriere. The panel opinion rejected the clear and present danger standard. They said, no, that standard's wrong, so we're not using that one. But it also said that a significant and imminent threat reflects more demanding scrutiny than the substantial likelihood test. Okay, that's like, what is that? A substantial likelihood? What kind of a garbage standard is that? There's a substantial likelihood that a lot of things happen. Doesn't mean you gag somebody's free speech over it. We need a much safer protection for free speech. Jack Smith, a substantial likelihood that Trump's going to say something that offends somebody. Yeah, that's true. It's Trump. So it needs to be, in my opinion, something much more strict, right? Clear and present danger sounds right. But the panel's opinion standard, it falls somewhere between the two. Sixth Circuit was hard on one side, Fifth Circuit's hard on the other. They're kind of splitting it. Now, because the panel plainly envisions that the three standards, they materially differ, they create a three-way circuit split. Nice job, guys. And so the panel opinion also holds that the clear and present danger test has no legal mooring, and so they're not going to use that one. Now, they continue saying it's also conflicting not only on the standard, okay, so we know that the one standard is a lot more exacting, a lot more difficult to meet than the others, but they also disagree about the importance of campaign speech. So a couple different prongs on this one. Similarly, we have problems with the campaign speech standard. The panel opinion permits significant restrictions on core political speech of a defendant who is a political candidate. But by contrast, different from what the Court of Appeals has done, in these other cases, Ford and Brown, the defendant candidate was given virtually unfettered discretion to speak publicly. So even though they disagreed on the standard, they gave the defendant who was running for office a lot of leeway. They say in the Ford case, for example, the Sixth Circuit gave Congressman Ford unfettered latitude to speak about his prosecution. They said that the defendant, a Democrat, is entitled to attack the alleged political motives of a Republican that's persecuting him because of his political views. That's the Ford case. That's right. You should be able to speak about that. If Republicans are prosecuting Democrats, absolutely, they should be able to speak about that. Just like Republicans should be able to do now. The court reasoned Ford is going to be up for re-election soon, and his opponent will attack him as an indicted felon. Sounds like deja vu, doesn't it? He'll be unable to respond in kind if the order remains in place, and he'll be unable to inform his constituents of his point of view. Yeah, that's like a sane opinion. That's what we want. Chutkan says Trump's constituents are just MAGA insurrectionists. Who cares what they want? Now, likewise in Brown, which is in a competing circuit, the district court also, which was the less scrutinous standard, by the way, so like the easier standard to meet, even they lifted it. They temporarily lifted the gag order to avoid interfering with the re-election campaign. The courts don't want to interfere with other people, but they'll happily do it with Trump. Now, the district court made special allowances, and citing this decision, they said that a candidate for the benefit of the electorate, that's us, as well as himself, they have absolute freedom to discuss his qualifications. Now, though they disagree on the legal standard, they closely aligned in the outcome. The standard was met in both of them. Virtually absolute freedom to a candidate defendant as he's running. Now, indeed, the gag order has been criticized. Chutkan's gag has been criticized across the political spectrum for interfering with voters and their ability to hear from the leading presidential candidate. Muzzling him is going to disenfranchise tens of millions of Americans who want to vote for him and who want to hear about one of the key issues in this case, in this entire election, which is the weaponization of the DOJ, which is the political prosecution by Joe Biden of his political enemies. We need to hear from the person who is the best witness in the whole country to speak on it. That's Donald Trump. 4 different indictments brought in 4 different jurisdictions. There's nobody else, literally, that can speak with the authority that Trump has, and they're trying to gag him so that he cannot do that. So in stark contrast, the panel opinion here treats the fact that Trump is the leading candidate as virtually insignificant, right? The other courts, the Sixth Circuit, the Fifth Circuit, they said, well, the voters really matter, you know? Not only is free speech Trump's rights, but it's the right of voters in the primary and the general elections to hear from him. And the court should permit voters access to his statements. So we, the American people, people can exercise our First Amendment rights to receive information from our political candidates. Now, the panel's opinion notes the crucial importance of campaign speech, but when it actually analyzes the question about campaign speech, it explicitly declines to give the presence of campaign speech any weight, treating it instead as a political speech generally. That's all, not a campaign, not that important. Now, this analysis contradicts the Supreme Court precedent, and it instructs that the First Amendment has its fullest and most urgent application precisely when we're talking about campaigns for office. But the panel, even though it cites this principle, it cites it like they reference it, it disregards it in the analysis. So you got two prongs. What is the standard? And then what is the type of speech? And you measure the type of speech against the standards. Now, the panel in DC, they disregarded the campaign speech doctrine. They just got rid of that whole second prong. Well, we don't really need to analyze it. The panel said in a footnote, they said, quote, "At oral argument, Mr. Trump stated that his position would be the same even if there was no political campaign underway, as he would still be engaged in political speech. And so, given that position, we focus only on protection of political speech generally." They're basically saying like Trump's defense like waived that or something. Not true. At oral argument, Trump's counsel stated that if there were no campaign, our position would be that it's still unconstitutional, but that the campaign adds a very powerful reason why it is unconstitutional. They described campaign speech as the crown jewel of the arguments favoring reversal, while also emphasizing several independently sufficient grounds for a reversal of the gag. Now, Trump did not waive his reliance on the campaign speech doctrine by describing it as his most powerful and compelling argument. See what the court did? He just kind of waived it. No, he didn't. It's his number one argument. But they said, well, because you said it's going to be the same regardless, we can just kind of delete that. Now, President Trump's assertion of, quote, alternative grounds, meaning if you find that that's bad, it's still free speech, does not negate the Supreme Court's instruction that this is the most urgent application of free speech when we talk about campaigns. Now, continuing. Similarly, they also neglected to consider this all a heckler's veto. Said the panel's opinion relies heavily on the audience's anticipated, quote, reaction to President Trump's speech, specifically the concern that President Trump's speech might lead to unidentified third parties, random speculative people that nobody's identified. They might threaten or harass the trial participants, which is already illegal. You can't do that. So if that happened, they could just prosecute those people. Now, this justification contradicts the case law of the Supreme Court. Under the First Amendment, public speakers are not chargeable with the danger that their audiences might react with disorder or violence. Why? Because we want to incentivize the people who do the violent thing to not do the violent thing. So if you blame the speaker, okay, so if Trump comes out and he's the person responsible for the disorder or for the violence, then the people who committed the disorder or the violence, they're immune? They're exonerated? In other words, you can take away their criminal liability and reassign it to Trump. That's insane. We want people, as a matter of public policy, to be responsible for their own misconduct, not blame, no, he made me do it, okay? Remember when you're 8 years old, right? And your mom busts you for something, you know, you did something with that explosive, you lit something on fire you shouldn't have done, and you say, well, he made me do it. He told me to. Your mom says, is he in charge of you? Are you your own person? If he told you to jump off a bridge, would you do that? My mom said, if he told you to jump off a cliff, would you do that? Love you, Mom, right? You know how many times I heard that growing up? Would you jump off a cliff? No. So it's the same thing, right? They can't figure this out. If a person speaks, it's the person who does the thing that's responsible, not the speaker. Now, the panel opinion distinguishes these cases on the grounds that they involve speech that might, quote, offend a hostile mob. So, like, they use that word. That's free speech now? Being offensive? Now, here the panel is concerned, they said that, quote, that Trump's, quote, Trump's followers will act minaciously in response to his words. And under Supreme Court precedent, however, this distinction makes no difference. Speech cannot be prohibited based solely on an audience's reaction, regardless of whether that reaction is hostile to the speaker or hostile to those the speaker criticizes. The government may not tie censorship to the reaction of the speaker's audience. Here, the incitement doctrine forecloses the Court of Appeals analysis. Unless speech qualifies as incitement to imminent lawless action, which is that Brandenburg standard again, which President Trump's speech does not. He's not telling anybody to go do anything like that. It cannot be prohibited on the ground that it might lead some third party to misbehave. Such a restriction is violating of the Constitution. It impermissibly intrudes upon the freedoms guaranteed under the First Amendment, and the Supreme Court treats this rule as categorical. But the panel disregards it. The Court of Appeals just said not that important. So in so holding, the panel opinion sets an especially dangerous precedent in the current age. Third-party heckling by random listeners is an all too frequent feature of online discourse. Speech by any high-profile public figure on any controversial issue is followed by abusive comments from unrelated parties all the time, which can speedily be characterized as harassment or threats by those those who want to silence the viewpoints. Now, the panel's opinion from the Court of Appeals provides a sleeper justification for silencing enormous quantities of core political speech on matters of utmost public importance. Indeed, it is this exactly what happened here. The panel silences Trump because it anticipates that some tiny minority of over 100 million listeners over whom he has no control might heckle others in response to his core political speech. Right? Think about just this as a percentage. If there's 100 million people, probably a lot more than that, you just run the percentages on that. Okay. Like, what is 1% of that? What is 1/10 of 1% of that? It's still a lot of people, whatever those numbers are. And if that one person does something, which they may or may not do, it's just, entropy, basically. It's just chaos in the world. They're going to blame Trump for that. And he can't speak. And that means that 99.999999 million of the rest of his listeners can't get to hear him because of a couple people. That's the standard that we want in America? Obviously not, because that would allow the government to prohibit speech wherever they want based on whatever they make up. Now, the panel also forgets about the solidity of evidence. Okay, they don't have any evidence. The Supreme Court has emphasized the importance of evidence and a burden for restricting pretrial speech. They told us that we need a solidity of evidence to justify it. They say to justify a prior restraint, the substantive evil that the person is speaking, it must be extremely serious and to the degree of imminence extremely high before utterances can be punished. And a solidity of evidence is necessary to make the requisite showing of imminence. Like, that is a tough standard, man. And that's a 1947 case. The danger must not be remote or even probable. It must be immediately in peril. Has Trump said anything quite like that? Not to my knowledge. Of course not. Now, the panel's opinion justification falls short of this. The prosecution produced no evidence of any threats or any harassment received by any court staffer, any potential witness or prosecutor in this case. Okay, they might have got some stuff over from Areola Engeron, but not in DC. Instead, the panel relies heavily on supposed threats that occurred nearly 3 years ago, before the indictment even dropped. Now, in less stringent context, the court rejects that attempt, and the panel erred by disregarding this guidance. Now, they say the full panel is also warranted because it mistakes and overlooks key aspects of fact and law. For example, the opinion panel came out and they said that, quote, the day after Trump said, "If you go after me, I'm coming after you," one of his supporters called the judge's chambers and made racist threats. Now, the panel concluded that Trump and his post caused the threat, but President Trump's post did not refer to the case at all, but to reports that the Koch brothers were funding PACs against him. So Trump wasn't even talking about the case. So moreover, the panel overlooks evidence from other dockets and saying that Trump did not cause that threat either. The credited testimony at this detention hearing states that the threat was inspired by her watching the news. Okay, so this person, Schrei, has already been prosecuted. Okay, so there's a docket in Schrei. Apparently she called, made some threats. Schrei's father testified because she's been charged. Okay, so like she made a threat and they charged her. Okay, there you go. End of the story. But they now want to gag Trump on top of that, saying that Trump caused Schrei to do the thing. Not true. Dad said for Schrei, she's a non-violent alcoholic, sits on the couch all day watching the news, not reading Trump's True Social posts while drinking too many beers, becomes agitated by the news and starts calling people and threatening them. Like I said, man, they will arrest you for this and put you in prison for this. I've seen it. Social media is not mentioned, since the most pervasive subject on the news at the time was special counsel's inflammatory press conference announcing the indictment. If anything, the evidence supports the inference that the threat was inspired by the special counsel. Jack Smith caused this, not Trump. So blame him. You see where this problem is on causality? Like, they can't show causation at all, and they just fill in the gaps however it serves them best. They say the panel also states that President Trump's social media post accused Pence of, quote, going to the dark side and making up stories about J6. But Pence at that time was still a rival candidate for Republican nomination. And so the Pence campaign, they offered merchandise on their store. They offered a hat and shirt that said "Too Honest." Pence fundraised off Trump after Trump made a post about it. Apparently, Trump told Pence, allegedly on August 1st, that "You're too honest. Okay, you're too honest, Mike. You should just do what I say. Be dishonest and do what I want you to do." So then Mike Pence said, "I'm too honest," right? So the panel opinion assumes that Trump had no valid interest in speaking about prosecutors other than the special counsel. Not true. We make fun of Thomas Wyndham and Molly Gaston and Jay Bratt all the time here. Okay, they are the line prosecutors with open bias against Trump. So we should absolutely be allowed to talk about them. Of course, you can't talk about the prosecutors, the people who are doing the things. This overlooks that one of the prosecutors raised concerns about undue political influence by meeting at the White House, where they were discussing what constitutes constitutes core political speech. And the opinion assumes that Trump has no valid interest in speaking about the special counsel's family member. Why not? This overlooks the fact that the special counsel's wife, Jack Smith, has close ties to the Obama family, which raises concerns of political bias that constitute core political speech. So if he wants to rag on highlighter Molly, if he wants to rag on Miss Deranged Thug, that's fine. Now, as these examples, many others demonstrate, the First Amendment injuries are not allayed by the panel's opinion and their attempt to narrow the scope of Chutkan's gag. Okay, they know Chutkan's gag is bad, and so they're like, can we save this thing? Can we salvage this in some way? The order is modified, that they modified. It still suppresses large quantities of core political speech that are relevant in a presidential campaign. Among other things, it silences the leading candidate from making specific comments on the, quote, potential participation of, quote, reasonably foreseeable witnesses. I don't know who that is. Reasonably foreseeable? Does that mean everybody from the January 6th Select Committee hearings? Like every single person? Does that mean every single person who was there counting votes that day? Every congressman, Mike Pence, Liz Cheney, all these people? Where the reasonably foreseeable witnesses comprise major public figures who are on the media all day attacking President Trump. You got Pence, you got Barr, and similar figures. Now, for its other restrictions, the order imposes a mens rea requirement. So a mindset, a mental state, okay? But the panel opinion then ominously suggests that virtually all statements that result in third-party heckling will satisfy the mens rea requirement. So in criminal law, we often will break up crimes into two components, a mens rea and an actus reus. You need a guilty mind. So what is your intention? What is happening in your mind? Are you acting with intention? Are you acting with negligence? Are you acting recklessly? Do you intend to wake up and murder that person? Then you have an intentional mindset. You also have an action. And so what they're saying is the action would be the murder. Okay, then you actually go and shoot the person. So you got the two components. But they're saying here, Trump, that any third party, basically that anything is going to meet the mens rea requirement. If it results in an action, they're going to presume that Trump has the guilty mind that his statement was made to go and cause the people to do the thing. So both the gag order and its effect, they say, are unconstitutional. And we get to the conclusion, they tell us this petition for panel rehearing or en banc consideration should be granted. And the court should enter an administrative stay of the gag order pending consideration of this petition. And we hope that they do. Now, they may not. And if they don't, then the next stop will be the Supreme Court of the United States. If they do grant it and they actually hear the full case and they rule in Trump's favor, then we'll see Jack Smith appeal this one to the Supreme Court to try to reimpose the gag. I have no doubt about that. So this is what Trump has submitted. The rest of the document, which is available at robertgovea.com if you want to access it, is just addendum stuff and stuff we've already covered here. So you can certainly check that out. But people like Liz Cheney, okay, who have been actively anti-Trump for a long time, are saying that Trump is going to unravel the rule of law. Is Trump allowed to comment about her? Is he allowed to say anything about her? I have no idea, because we don't have a witness list and we don't know who's on it. Is she reasonably foreseeable? I would argue that she might be a witness just based on the fact that evidence is missing, right? That we've got missing records that Trump wants to review and her committee was in possession of them. So she's a witness to the gathering of evidence in this case, almost like a police officer would be. So this is Liz Cheney, and she is now speaking out. Don't know if Trump can respond to her because he's still been gagged.
You're fearful of a second Trump presidency.
I am. I think that we know what he will do. He's already done it. We saw what he did after the 2020 election, obviously what he did to try to seize power in 2020 and of course on January 6th. And he tells us every day. And if you look at the steps that he would have to take in terms of simply refusing to enforce court orders or comply with court orders with which he disagrees, putting people in key positions as Attorney General, for example, or as head of OLC, unethical lawyers who would help him, frankly, blow through many of the guardrails of our Constitution. I think it's a very real concern.
Unbelievable. She just listed everything that they're doing, like install people like Jack Smith to prosecute your political enemies, install people like Merrick Garland to cover up from your crackhead son, and so on and so forth. It's everything that they're doing. Trump has the absolute right to appoint his Attorney General when he wins back the White House, and I hope he does. And I hope he goes and investigates all of this election interference, all of this obstruction of justice, all of this malicious prosecution that was brought by Liz Cheney. And so she goes on Fox, which is pretty amazing that she's there, and says everything that the Democrats are doing.
Concern that he would take steps very quickly that would unravel the rule of law.
You're fearful.
Amazing. So that's Liz Cheney. And we also have a similar type of story from Chris Christie lecturing all of us. You should be ashamed. How dare you not vote for me? This is Chris, and what he has has to say. Now, my question again is, can Trump comment on this guy? Probably could blast him, right? He could comment on him because he has nothing to do with January 6th. But here is what he said. He said, those who support him, those who are enabling him should be ashamed of themselves. Here's Chris.
He's disgusting. And what he's doing is dog whistling to Americans who feel absolutely under stress and strain from the economy and from the conflicts around the world. And he's dog whistling it to blame it on people from areas that don't look like us. And look, Jake, the other problem with this is the Republicans who are saying this is okay. Almost 100 members of Congress who've endorsed him. Nikki Haley, who this week said he is fit to be president. You're telling me that someone who says that immigrants are poisoning the blood of this country, someone who says Vladimir Putin is a character witness, is fit to be president of the United States, was the right president at the right time? Nikki Haley should be ashamed of herself. And she's part of the problem because she's enabling him. She's enabling him by saying to people, it's okay. Let me be really clear. I'm in this race to let people know it's not okay. It's not okay for an American president to be saying these things. And she should be ashamed of herself.
All right, so that's Chris Christie giving us the nice lecture. And Liz Cheney's out there, and a lot of other people are talking garbage against Trump. And he can't really say much about it until we get some clarity on the gag. Now, of course, we'll be here continuing to cover this, my friends. We'll see what the Court of Appeals does, whether they grant a hearing. If they don't, it'll go up to the Supreme Court. I have no doubt about it. We'll be here to cover that. Thanks for checking out robertgovea.com, by the way. We got our new merch store up. And so if you want to grab the new Hillary Clinton sandals, Flip-Floppin' Hillary, if you want to grab the new Joe Biden sandals, Flip-Floppin' Joe Biden, they're over there at robertgovea.com/shop. And we love it if you checked it out. And we'll look forward to seeing you over there and back here on the next one.